Hi, my name is Robert Shelley with Chelle Law, and my law firm assists professionals with employment contract issues. Today I'm going to talk about how can an employment contract be terminated. In any employment contract, and like kind of the whole purpose of them is to dictate the terms of the employment relationship, and one of the most important parts of that relationship is figuring out how does the contract end. It can end in a number of ways. First, generally most employment contracts are for a fixed term, so that could be 1 year, 2 year, 3 years, and then there may be language that states at the end of that fixed term, it just automatically renews for another year, and then another year it just continues on forever until terminated. So that's one way that the contract can be terminated. The second could be for cause. So meaning if somebody breaches the contract, and most of the time there will be a list of things that the employer can terminate the employee for. So if they're in an industry that requires some kind of licensure or insurance or special certifications, and then the employee loses those, then obviously the employer can terminate the agreement because they can no longer function in that job. There also will usually be some kind of broad language about, moral turpitude or criminal activity and convictions, those types of things. So in a scenario where a professional is in breach of contract, generally the employer would give them some kind of notice, and then it's called a cure period, and then the employee would then have a certain period of time to fix whatever the problem is. So usually it's between like 15 to 30 days. Now, obviously, if you lose a professional license, you're not going to fix that in a month. It's not going to happen. So in that scenario, the contract can be terminated immediately. But if the employer is just saying they're in breach of something that can be fixed, maybe they're not working the hours that they agreed to, or maybe there's call that they are just refusing to take, something like that can be fixed. Those are the things where the employer would give written notice to the employee and then would allow them that period of time to cure whatever breach is. The opposite can be true for the employee. If the employer is in breach of contract, let's say they're not paying the agreed upon price, or maybe they're not paying in the schedule that they said they would, or they're calculating bonus compensation incorrectly. In those scenarios, the employee can do the same thing. They can give written notice to the employer and they can say, hey, you're in breach of contract. You're not paying me what we agreed upon. You have 15 days to fix the problem, pay me correctly. And if you don't, I can terminate the contract immediately. And then the last way that a contract can be terminated is without cause termination. And so in most employment contracts, there will be some kind of notice period required. So most of the time, you can't just say to them, hey, I'm leaving tomorrow, and that's it. I'm terminating the agreement tomorrow. There'll be at least some kind of notice period to allow maybe not a smooth transition from an employee leaving an employer, but at least provides a little bit of time for both parties to kind of get things together, to wrap up relationships with patients, clients, customers, or for the employer, it allows them time to look for a replacement or provide, like in the healthcare industry, some kind of continuity of care, transitioning the patients to a new provider. So most of the time, it's going to be somewhere between like 30 to 90 days of without cause termination. And so in that scenario, the employee would give written notice to the employer and say, pursuant to the contract, I have to provide 60 days written notice to terminate the contract without cause. Here's my notice. My last day of work, will be this date, and then that's it. So you can the initial term can expire. You can terminate the contract for cause if there's a breach, or the contract can be terminated without cause and there's no reason. So, if you terminate without cause, you can do it at any time with the, correct notice for any reason. You don't need to provide some kind of long explanation as far as why you're terminating contract without cause. I mean, when I talk to people who are unhappy with the job and they're like, all right, well, how do I get out of this contract? What are my options? And then it's determined that just give them without cause notice and move on. If at least I think most of the time the professional wants to explain all of the reasons why they're deciding to leave. And I think that's a bad idea. There's just no benefit to that. You just say, here's my notice that I'm providing, appreciate the opportunity, and moving on. Using this as like an opportunity to air grievances or point out all of the problems with the employer, there's just no upside to doing that. You're going to cause bad feelings, and you never know when a relationship can swing back around. So maybe under new management or something like that, the job that turned out to be not that great can maybe be another great opportunity. And if you burned a bunch of bridges, you're losing a potential opportunity down the road. So anyway, hopefully that was helpful about how a employment contract can be terminated. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can reach us through our website, ChelleLaw.com. That's CHELLE law.com. Again, my name is Robert Chelle, and I appreciate you watching the video. Thanks.